So the first due is to read the will thoroughly. So if the decedent created a will, they have a guideline on how they want their assets distributed, who they want appointed as executor, where they want their assets to go, and if they want to make specific requests, that's something that we'll need to follow and you need to follow as executor of the estate. So it's very important that if there is a will, we look at that. That's what the court's going to look at when we go to distribute the assets. So if there's a specific request in the will and here the executor gives it to another person, the court's obviously going to notice that, and then there could potentially be an issue. But if there's a will, we need to follow it very carefully and make sure that everything is done in accordance with how the decedent wanted it to be.
Okay, that's great, Natalie. Another one we have is make sure you file the will with the probate court, right? And we want to file that will as soon as possible. Far too often we see cases where people are fighting over which version of the will is the valid will, right? Natalie and I are currently working on a case where a client updated their will 3 years in a row.